Hi, very good afternoon, everyone, and thank you for joining us today. This is the fourth in our series of webinars on India's data protection law. We've discussed who's who, what are data fiduciaries, what are data processors, what are notice consent requirements, what are legitimate uses. We've sort of thought through the UI UX on a platform. Today, Prajit and I will be discussing other do's and don'ts for data fiduciaries. What are other things that you need to do under the law? What are your obligations with respect to the individuals? What do you need to do to be in sort of in compliance with the law? What do you do with the data that you have? Do you retain it indefinitely? Do you erase it at certain points? And what are rights of individuals and how platforms can give effect to those rights? So the way we'll structure this today, like for previous sessions, I think I'll just start with a very brief intro or an overview of the different obligations of what data fiduciaries should do, and then jump over to what are the different rights that individuals have, what that translates into practice, what that looks like on the platform. And then we'll have a freewheeling sort of conversation on some of the more interesting aspects of data fiduciaries obligations. With that, I think I'll jump right in on what these obligations really are. So I think we've discussed multiple times over in the previous sessions that it's really the data fiduciary. Data fiduciary is the entity, just for a quick recap, that's calling the shots around that data, that controls the data, has discretion around using, collecting, storing, sharing data. And the way that the law is structured is that the brunt of obligations, the entire gamut of obligations within the data protection law are all placed on the data fiduciaries. It is the data fiduciary whose neck is on the line at all points on compliance. So really the first sort of overarching obligation is that data fiduciaries are responsible for compliance overall, whether they do it themselves or they get it done through third parties, through vendors. They're the ones who are responsible for complying with the act, with any rules that come in respect of processing that they're doing themselves or processing that they're getting done through processors. And the law also requires them to, when engaging a processor, have a valid contract. We've discussed what this might look like, but typically the contract will have stipulations around here is the data that you will be collecting and using, here is what you will be specifically using it for. Clauses saying that you can't use the data for anything else. Then clauses around engagement of sub processors. What should you do in case data processor wants to engage further sub processors? Are there any checks and balances there? What happens in case there's a data protection board, the data protection board or any individual makes exercises rights with respect to their data? Typically, the contract will also require data processors to help the data fiduciary out. So essentially, all of the obligations, whatever is relevant, that those obligations will be passed on through that contract between the fiduciary and the processor. And the fiduciary must ensure that there is such a contract in place. The law doesn't specify what are the 10 items that should be in the contract, but it says you must have a contract. Then, interestingly, the data fiduciary is also required to ensure completeness, accuracy, and consistency of that data. And this one we'll dig into a little more on what that really means. Is this an active obligation to ensure that the data is always accurate? But it is sort of, in two conditions you have to do this: when the data is used to make decisions about the individual, or when it is disclosed to another data fiduciary. But we'll unpack this a little more in our conversation. Then the law requires the data fiduciary to implement. It's a broad framing. It says you must implement organizational and technical measures to carry out or to comply with the law. Effectively, we read this to mean, while this law, unlike some other global regimes, it doesn't specifically call for, say, it doesn't specifically call for privacy by design, but the idea is that from the time that data comes into your life cycle, the data is, comes into your systems till the time it leaves your systems, you put in place enough checks, It could be process measures, it could be people related controls, access controls, it could be contractual controls. Essentially everything that you need to do at an organizational level, technical means as well, security related processes. You implement all of these to ensure that you can give effect to the law in its true sense. So it's a broad framing, but the idea is that you make changes at process level, people level, and also just contracts, what the product looks like. I think the last session we spoke at length around what the UI might look like, what are pop-ups that might be shown to users at while taking their consent, while giving them notice. So essentially reimagining product, tech design, all of these different functions and blending those in to make sure that you're able to abide by all different obligations under the law. Data fiduciaries must also implement security measures. It could be depending on the nature of data, encryption or access controls, any other specific measure that you think is necessary given the nature of data that you are processing or the sensitivity of data you are processing as well. And you must also make sure that data processors are implementing security measures, which can happen again through the contract where you ask them to abide by certain do's and don'ts. An important piece again is on data breaches, that the data fiduciary must notify the data protection board. I think we've discussed earlier that there will be a data protection board and enforcing authority that is set up to adjudicate and award penalties under the law. And the law says that if there is a data breach, then you must notify the board. You must also notify the affected individuals. The objective here is that then in case there is, individuals must know that their data is out there in the web, and that if there are any remedial measures that they can take. For instance, I think the most common one we've seen is, say, change your passwords, some sort of baseline, some basic hygiene practices also that you might need to tell individuals at that point, where essentially the idea is you let individuals also know what's happened and what they need to do to protect themselves. Then a very sort of interesting piece is on data retention, whether data fiduciaries can only retain data as long as it is necessary for the purpose for which they collected it. If the purpose for which they collected it is no longer being served, then data fiduciaries actually have an obligation to erase that data. Or if the individual has withdrawn her consent to data being processed by the data fiduciary, then data fiduciaries will have to sort of erase that data. And this also we'll dig into a lot more, because there are some nuances here on, does this mean, can you continue to hold on to data that is required for a legal purpose or to defend yourself in a claim? What are the purposes for which you can actually retain data? Can you retain data indefinitely? Is there any purpose or any piece of data that you can retain forever? And that we'll dig into. And the last obligation that I just want to briefly talk about is that you'll have to, if you're a significant data fiduciary, then you appoint a data protection officer, or if you're not a significant data fiduciary, then anyone like a grievance officer currently we have under the SPDI rules, you will publish their contact details on the website. The idea here is that individuals are able to reach out to a grievance officer or to a data protection officer to exercise their rights, to ask questions, to really liaise with the platform or with the company, have a point of contact in the company who can respond to queries around data use. If you're a significant data fiduciary, there are 3 additional things that you need to do. You have to appoint a data protection officer, that is, who is based in India, who's fairly senior level officer, because they'll have to be directly kind of accountable to the board. That's one obligation. The other is that you conduct data protection impact assessments, and more details will be set out in the rules. But the idea is that whenever you're carrying out or starting, say, rolling out a feature which will have implications for user, which can have a new use case you've thought about. For instance, if you're starting a loyalty program, or you're wanting to cross-sell a different product or feature, in those situations, you should conduct a DPIA. For those who are familiar with, say, GDPR parlance, the idea being that you check what are the risks to individuals, what are the ways in which to mitigate those risks. So that's also required under the law. And the third is that you appoint data protection auditors and you carry out periodic audits. So that's on the side of data fiduciaries and what significant data fiduciaries need to do. On the side of the individuals now, as individuals, we all have certain rights that have been granted to us under this law. The first is just what information you can access from the platform, from the data fiduciary. Individuals can seek a summary of the data that the platform has about them, that the data fiduciary has about them, and a description of the processing. Importantly, the individual can also access the identities of all the data fiduciaries and the data processors with whom the data fiduciary may have shared the individual's data. Not just a category, but actually calling out the identities of the DFs and the data processors and any other information that the government prescribes here. So the first right is of access to a summary of data, description, names of the people with whom the data fiduciary has shared data. The second right is to seek correction, updation, completion of any data that is inaccurate or incomplete. And essentially an individual can make a request saying this address on file is incorrect, please correct it, or can make a request saying my name is not appearing correctly, please correct it. This right is also only available in cases where, as is the access right, only available in cases where the original basis for collection, that you've collected the data based on that individual's consent only, or her having voluntarily provided you the data. So you also allow parallel correction erasure rights. And erasure as well is part of this, where you can tell the data fiduciary that the purpose for which you've collected it is met, please erase my data. You can seek withdrawal of your consent as well in these situations. The third right is the right to grievance redressal, that there should be readily available means of grievance redressal that the data fiduciary provides, or a consent manager could provide as well on behalf of sort of the data fiduciary. So a point of contact with the organization, so that the individual can make these requests, can understand what data about them is being collected. The time period within which you have to respond to these requests is not set out under the law, but the government is likely to prescribe that time period. And before approaching the board, you can of course make complaints to the board as well, that some right of yours hasn't been granted, or you have a grievance in the way that the data fiduciary is processing your data. But before doing that, you should exhaust these grievance redressal channels that the data fiduciary is providing you. And the fourth right is data principals can also nominate someone in case of sort of death, incapacity, who can exercise these rights on their behalf. So that's just a snapshot of what the obligations are and what the rights are. And I will invite Aprajita to also now come in.
Hi, Srinidhi. I think we've gone through a whole list of obligations that a data fiduciary needs to bear in mind. Do you see these list of obligations as a compliance first activity, or is it larger than that?
Yeah. So of course it is a compliance obligation. There is a strict penalty also that is waiting for you in case you don't comply, which goes up to 250 crore. But at the same time, over the past several years, we've seen this sort of space evolve, and I think it does require a kind of mindset shift in the way we think about data. And I'd like to sort of think of it as just beyond compliance. It's more about data hygiene. We've had some folks also tell us often that it's not just a way of for you to think about users' privacy. It's also your own data assets and how you're managing them. You identify and understand what you're collecting, what you need it for, what are the specific uses to which you want to put it, just greater hygiene within the organization in the way you're managing your data assets. And also this larger theme of breaches are sort of, almost inevitable. Everyone experiences some kind of a hack, some kind of a security incident, minor as well. And as cybersecurity incidents or hackers become more sophisticated, attacks become more sophisticated, there are certain checks and balances that in any case we see organizations put in place. You don't want to sort of leave banana peels on the floor, even without the law requiring you to do that or not. That basic sense of hygiene, we've seen organizations increasingly try and bring in. For some platforms, in fact, that also becomes so. I mean, just on the cybersecurity piece, it's more also a question of reputation. Often, data breaches can be massive hit for reputation. Goes to the core of, say, trust that an individual has with the platform, especially for platforms, say, that are financial tech platforms or health platforms, where there is already that element that the data is a little more sensitive, or the propensity for harm, potentially, there could be actual frauds, where there are those instances. Even it's in the platform's interest also to maybe manage their data assets a lot better. So I like to think of it as just not just a pure compliance function, but it's a business risk as well. It's not just a risk to the privacy of individuals. It's larger than that. Some organizations also treat privacy as a differentiator, as a USP, that this is sort of the value that we provide, actually, where there is no other alpha. It's the same product, but what we are doing is we're creating an ecosystem where your privacy is protected. So that's also a theme that we're increasingly seeing, that privacy as a differentiator, if everything else is the same.
Yeah, yeah, I think that's fair, right? And in our conversations with various different platforms, the way DPDP will interact with their platform, both from a user-facing perspective and at the back end, would mean re-architecturing how the user consumes the product. What does she see? How much do platforms need to reveal? They need to say, what am I going to use your data for? So, A, it's a re-architecturing of the entire product, I feel. And B, also the way in which platforms have written their business models. How are they going to monetize? And we spoke about cross-selling, I think, even in our last webinar. I collected data for one purpose, but I cross-sold 10 other products, and therefore the lifetime value of the customer will justify the acquisition cost of the customer. I think that also needs to be realigned. That is strategy 101. That isn't a compliance, that isn't a check in the box. That is telling a platform that, hey, look, your ability to use data as a part of your monetization or profitability path may be completely upended, or may in some way be fractured, in fact, post DPDP, as opposed to what it was under the IT Act. So align that it isn't a pure compliance activity. The compliance, the management, the product, the engineers, everyone would have to come together and kind of align in terms of whether they want to follow the baseline of the DPDP, or, like you said, use privacy as a design feature which is meant to differentiate amongst commoditized products. So I think fair. But what happens, Srinidhi? Platform doesn't comply, willfully doesn't comply. Look, just didn't care to comply with the DPDP. Alternatively, what happens to platforms who've put in all of the but somehow they still find themselves at the short end of the stick, like they've not complied with the DPDP for any way. What can platforms do now to mitigate the amount of penalty that is slapped on them in case they are found to be in breach?
Sure. So to your first question of what happens if you don't comply, there are penalties prescribed in the law for different kinds of breaches. Say for breaches, if you haven't taken reasonable security safeguards to prevent a breach, that's the highest penalty prescribed, which is 250 crore. Fairly significant sort of amount, fairly significant penalties that are prescribed. Then
It's balance sheet shaking. It's like you for a small company, it may be many times its EBITDA. So,
yeah,
I mean, and it's agnostic of whether you're an SDF or whether you're a significant data fiduciary or not. So
correct.
you could be a small tech startup and you're still exposed to up to 250 C.
That it's a blanket sort of upper cap, 250 crore. Then there is a 200 crore maximum penalty if you don't notify the board or don't notify the individual after a data breach. There are certain obligations set out for children, and if you've not abided by those, if you haven't, say, taken verifiable parental consent, or if you have monitored or tracked children, shown them commercial advertising without there being an exception, there's a penalty of 200 crore. If you're a significant data fiduciary but you haven't appointed a DPO, you haven't done a data audit, you haven't done a DPI, then it's a 150 crore penalty. So there are such penalties prescribed for certain things that are set out in the law. The interesting piece, of course, is that it's sort of 0 to 250. So the first, it does cause a bit of panic. It is a large number. There are, even service providers, if the contract value is just say 2 lakh, but the penalty that they're having to accept is an uncapped liability, which could go up to 250. It's a massive hit. But I think the law also does say that, look, when awarding the penalty, and of course some guidelines will evolve around this, but while awarding the penalty, there are a couple of things that the Data Protection Board will also keep in mind. What was the nature, gravity, duration of the breach itself? What is it that you did? What were the kind of mitigating measures that you took to in once that breach took place, whether it was repetitive in nature, whether you contained it, whether the person has whether it's resulted in some gain or loss to the person, whether the monetary penalty is proportionate and effective, having regard to the objective of the law, which is to deter breaches. So there are these guidelines or these factors at least that are set out in the law. So if you've done your bit, then of course you have a stronger defense in seeking a lower penalty. Your exposure to that penalty is a bit lower. And to your question on, I did everything I could, but there was still an attack, and it was simply unfathomable that I simply could not have prevented it. Because of the nature of the breach, or the nature of, if it's a security incident, the nature of the incident was so sophisticated that I did everything I could, but couldn't sort of avert it. I think that is a factor that will be taken into account. The fact that I did everything I could. And the analogy I draw often is just, if I've left banana peels on the floor, or if I've left my door unlocked, then of course I'm exposing myself to a bigger hit, higher penalty. But there's pre-breach and then there's post-breach. So pre-breach is everything that I've done, different checks through contracts, through the vendors that I've selected, ensuring that they are also abiding by implementing relevant security measures through contract and through other audit rights, and all of those rights I've secured. And once there is a breach, what is it that I've done after the breach? Have I immediately called on board forensic experts, lawyers? Have I figured out where did the breach originate? Was it at a processor's level? Was it my own systems? Immediately, what did I do to then contain it? Have I given individuals a notification, told them, here is what you need to do, here is what you need to do to comply, sorry, here is what you need to do to protect yourself. It could be something simple like change your passwords, or it could be that log in once again, log out of your existing devices, some sort of mechanism through which we've tried to protect users. I think all of that does get taken into account when you're awarding adjudicating and awarding a penalty.
So takeaway for a platform is, well, it's not a compliance check in the box activity. To mitigate the severity of the fine that can be slapped on you, and 250 CR is like, we mentioned, it's balance sheet shaking even for a big company, let alone if you're a small platform. To mitigate the wrath of the law, do your best in terms of showing that you tried to protect the breach. Okay, there's been a brute force attack, a sophisticated attack on your data centers, on your systems, etc., not entirely in your control. After the breach, what kind of damage control did you do? Did you tell Aprajita and Srinidhi, hey, I think your data has been under breach, we're doing everything that we can? How quickly did you move to contain this fuel spill? Right, and I think that's a little bit of an alpha over just a compliance check activity. That is organizational intention to protect the user. I think fair. Okay, now there is a hierarchical relationship, like you mentioned, Srinidhi, in the data protection law between a data fiduciary and a data processor. A data fiduciary sits on top, data processor sits below, data processor acts on the instruction of the data fiduciary. So if I as a platform tell my cloud service provider, hey, don't keep this data or keep this data data, for instance, in India, the data processor needs to comply with what I'm saying. A, under contract, and B, under the law, you're also, as a data fiduciary, facing the brunt of the law. How do you think this relationship, both in substance and in contract, will play out?
Yeah, you're right. There is, of course, that hierarchical relationship. So what that would translate in practice is pre-onboarding a new vendor. You do some checks, some form of a due diligence, where perhaps you ask them have you suffered breaches in the past? What are your security practices? Are you ISO 27001 certified? In case there have been breaches, what are remedial measures that you've taken? Anything that a regulator could ask you, you also ask the vendor that you're onboarding, because you're kind of entrusting them with your own corporate data as well. So ask them all of these questions pre that onboarding. In the contract, have reps and warranties that will ensure that they are compliant with applicable law, that they are compliant with, they have appropriate security measures. The one we've most commonly seen is, of course, the ISO 27001 certification. You tell them that you include covenants specifically prohibiting them from using that data for any other purpose, because you're also not allowed to use the data for purposes beyond what you've taken consent from the individuals for. So essentially, don't use data beyond the purposes. Tell them this is the data that we are entrusting you with. This is your remit. Don't use it beyond that. If they are engaging sub processors or sub vendors, how much control would you like to exercise over that process? Typically, what we've seen most commonly is there'll be a schedule with a set of processors that that the vendor in any case has, the large ones, with the option that if you're onboarding new sub processors, then either a right to object to those within, say, a certain time frame, and have the ability to say no because you don't think that that sub processor will be sufficiently secure. Then you typically have, because there is a whole brunt of obligations that you're directly facing under the law. So the data protection board could call upon you to share any information which will be relevant in an inquiry or an investigation. So you pass on a similar obligation, a back-to-back arrangement with the data processor, and you essentially in that contract also tell them that please help us in these investigations. So any information that the regulator calls upon us, please assist us in those. Provide us reasonable assistance in those supervisory investigations, and in case a law enforcement agency also comes knocking, then help us in responding to those law enforcement requests. Then if an individual makes a request, I think I just mentioned a couple of the requests or a couple of the rights that individuals have, which translate into individuals then making requests for that data, for accessing, say, a summary, or who are the data fiduciaries, data processors, erasure rights. So if there's a right to erasure and the data fiduciary has to erase that data, then they must also ensure that the data processor is erasing that same subset of data from their files, from their records as well. So essentially, all the obligations that are on you, identify what are the relevant ones. The ones that I've mentioned are fairly standard as well. Like these are kind of general, and typically you would pass those on to the data processor. There may be instances where, so these are more instances where the data processor may be at the back end, right? Like a cloud service provider. The individual is not directly engaging with them or interfacing with them. But there could be situations where the data processor is actually at the front. They are the storefront, and the not just the storefront, but they are the ones who are acting as the agent on behalf of the data fiduciary and going to like for some research purposes, you've engaged people who are going to door and collecting, say, information about medical history. So in that case, make sure that you're telling them that they'll get consent in a certain way. So everything that you're required to discharge, if that's a function that if the data processor is providing or discharging that function, then pass that on to the data processors. And the most important one, I think, is just ask to be indemnified in case of any loss or damage. Of course, that's the most critical one that we see, and that's the one that's most hotly negotiated as well. In fact, Prajita, I'll flip this to you also, because there's very much like a hierarchical relationship that we see within the RBI outsourcing framework, right? And unlike the PDP, where it just says have a contract. The RBI has set out, these are the 10 things that the outsourcing agreement should contain. So any learnings that we can actually take away from the RBI here?
Yeah, for sure. And just to zoom in on that, in the RBI outsourcing framework, and I give this analogy several times, RBI is the sun. It governs the planets. These planets are banks, NBFCs, basically regulated entities. The planets are then tasked with keeping their satellites in orbit. A technology service provider, a co-branding partner, someone who is doing marketing for you, anyone who is providing the app interface, etc. Right? So each RBI regulated entity and outsourced service provider, there is, each kind of body is playing its own role in keeping the other in check. Now, RBI has come up with an outsourcing directions, which says, where it's telling its banks or its NBFCs, its regulated entities, hey, look, I'm going to catch your neck if something goes wrong. You may engage outsourced service providers, whoever they may be, go ahead, engage them. But the agreement that you have with them must follow these basic minimum principles. The outsourcing guidelines don't have a standard template agreement between RE, regulated entity, and outsourced service provider, but they certainly have contours of what the relationship should look like. RBI is telling bank, hey, look, bank, you should you should only onboard a vendor after you've done due diligence on them. In your agreement with them, have these XYZ obligations, have the right to audit them, have the right to ask them, hey, are you outsourcing this to some other entity? Tell me who that entity is. Let me do a due diligence on them, due diligence on that subcontracting, right? I think this kind of a contours of an agreement in a hierarchical relationship such as RE and OSP, outsourced service provider and regulated entities such as which is there in the RBI outsourcing framework, should be replicated, or we should learn from that in the data fiduciary and data processor hierarchical relationship. I think that the rules under the DPDP should give some contours of what that agreement should look like. And why I'm advocating for that little piece of granularity is because these contract negotiations will become endless and will stall business. It's such a heavy fine, right? It's 250 CR. It's nobody wants to take the liability and nobody wants to give up indemnity for that. I can imagine a lot of these contract negotiations going like, I indemnify you, you indemnify me. I don't want to take the exposure of 250 crore for a 2 lakh rupees service vendor agreement for you, right? I can imagine a lot of data processors saying, hey, look, I am taking the detriment of the law, which is I have no access to the customer's data or right to process that data unless the data fiduciary instructs me to do so. I am a gun for hire. I only do what the data fiduciary tells me to do so. I am taking the detriment of the law as a data processor by not using that data for any XYZ reason. Tomorrow I want to cross-sell some other product, do some other business. I'm not using that data. So why should I not then get the benefit of the DPDP, which is to stay insulated from this 250 CR fine? I don't have it directly under the law, but don't pass it on to me contractually either. Let me protect myself as a processor. That's the business I'm in. I can imagine like endless time being spent on contract negotiation, especially that indemnity clause, without some guidance in the law which says, look, this is what you can outsource to the data processor. This is what you should have controls over. These are the kind of control measures there should be between fiduciary and processor. Without the contours of that agreement, I think contract negotiation, at least for the next few years, is going to become a uphill task.
Yeah, I think I kind of agree. I think even in the GDPR, which does set out some indication at least that these are the 8 things that you should include in the contract, but there are negotiations that sort of go back and forth. The sticky point often is indemnity and uncapped liability for breaches or for the entire piece, like anything to do with the law. But yeah, that's going to be a critical piece here for sure.
How long do you think platforms can retain data? Can they just keep it and say, my purpose never ended? I have an ongoing relationship with the customer. I'm just keeping it.
Yeah, I think this is one piece or concept that we've debated and discussed at length. So the law very simply says that you can keep data as long as the purpose as long as the purpose for collection is being served, so you're able to retain the data for a particular purpose. um, I took a loan. Very simple example is I drew a loan from a digital lending app from a lender. Until the time it's repaid, it is natural that that purpose, that relationship is continuing. And that's sort of how you think of the purpose there. You can also continue to retain data if it is required under a law. So if the PMLA tells you that reporting entities must retain transaction records for 10 years, you must do that. If companies law says that, Companies Act says that financial records have to be retained for such and such time, tax laws say that certain information has to be retained for such and such time, it's a no brainer that you have to sort of abide by. And the law recognizes that while data minimization is great for privacy, some laws do require you to hold on to that data for many different purposes. For money laundering, different laws have different objectives. Now, the interesting piece here is that the law says you must erase data once the purpose for which you collected it has been served. Now, would this mean that you craft purposes in a way that the purpose actually never gets, it's never completed, and sometimes it's also hard to gauge. For instance, if I've gone on to an online pharmacy, I've created an account. I haven't yet made any purchase. But at that initial instance only, I've given my number, OTP, I have an account that is created. At the moment, I haven't made any purchase, but I'm simply browsing the storefront. I'm looking at the different products. So the purpose is actually browsing the storefront. I want to look at that. I want to access the service. I want to access the platform. It's the parallel of going into a mall. I'm looking at what all is out there. Then I make a specific transaction. I purchase a certain medicine, and there's more information about me. And there's greater footprint now. There's a receipt that I get. There are medicines that are delivered to me. I enter my address there as well. Phone number was there already, but the number is also now being given to, say, a delivery agent to be able to reach out to me in case they when they're delivering the product. So that purpose, then there is other stuff that's added to that same purpose. So at what point would you say that a specific purpose is met? Would it be when that transaction is complete? Because my relationship with the platform is kind of going beyond just that individual transaction. I also came onto the platform because I want to browse it. I want to overall see what are medicines that are available there. In case I want to purchase something, then do I have to upload a prescription? There's a lot more that sort of I'm doing on the platform. So I guess it's also important how you define that purpose. But what the law says, it creates an assumption that there may be instances where the individual hasn't initiated any contact with the platform for a certain time period. That time period hasn't been prescribed, but the government will do that through rules. If it's a dormant account, it was created 10 years back, and I was using it for, say, 3 years. After that, I haven't opened the app in like a 7-year time period. Is that enough then to assume that the purpose is met? I have completed my relationship with the platform. So this, I think, this will be an interesting one. Just to see. I think the one piece which is very clear is when it's required under a law, you are able to retain it for that purpose. Then if it's an ongoing relationship where I'm continuously using the platform for different things, then the purpose isn't met. But where the account is, say, dormant for a while, can I continue to hold on to that individuals? Is it an active obligation then for me to make this check, to ask them, hey, do you want to continue using this account, or do you want me to erase this data? Do you want to deactivate the data? Do you want to update your information? Some kind of prompt. And the law seems to hint at this, that once there is a certain time period that's elapsed, and the individual hasn't made contact with you, it's kind of, you then assume that either they've forgotten that they have a relationship with you, so you remind them and then see if they engage. So I think that's the third piece that that the law is trying to build in. And also, just on the retention, it's when you're retaining data for a legal purpose, you can only use it for that legal purpose. So like the online pharmacy, if some law is requiring them to hold on to that data for a particular time frame, you can't actually use it for any other purpose. You can't use it to say send a loyalty program to the individual, or send them offers, discounts, vouchers, under that same justification, because the reason for retention is only.
Can you hear me, Srinidhi? You can. So just lost you. Reason for retention. That's why we lost you.
Okay. Can you hear me now?
Yes, yes. Can hear you. Can hear you.
No, I was just saying I've actually lost track of because I continued to speak. I don't know if people could hear, but so yeah, essentially the reason for which you're retaining it is then critical. If you're retaining that data for compliance with the law, you can only use that data for compliance with the law. If the PMLA has asked you to retain transaction records for 10 years, then that's the reason for which you're retaining that data, not to be able to send the customer, loyalty programs or vouchers. For that, you'll have to either rely on the consent that they gave, see if there's an ongoing relationship. So that reason also sort of is important there.
Okay. So from retention, I kind of want to move on to accuracy of data, right? One is reactive accuracy. Aprajita goes and tells Facebook, hey, my data is incorrect, inaccurate, incomplete, please correct it. Fairly simple. The other trickier obligation on DFs is proactive accuracy. That the DF or the data fiduciary itself must ensure that the data is accurate in certain circumstances, right? If it is using that data to make a decision, which is very broad, or it is using that data to share it with another data fiduciary. This proactive correctness, this is a how as a platform, how will how would they know if a Prajita is giving the right information or just fudging the information? How would they authenticate that in that data provided by her?
Yeah, so the law is fairly, it says that you have to ensure the correctness of that data, correctness, completeness, accuracy of that data in two situations, like you were just saying, that if it's used to make a decision about an individual, but anything big and small could be a decision. So I think some sort of tempering there on what are decisions what are we counting as decisions here. And the other is if you've shared that data with another data fiduciary. I think while the law here doesn't say reasonable efforts, some earlier versions did specifically call that out. While it doesn't say that, I think that is sort of the more reasonable way of interpreting it, that the platform has done something, given the context. They've taken some measures to be able to ensure accuracy, because otherwise there's room for a lot of technical violations of this provision. So say if an e-commerce platform, over the past 5 years, I've been at 10 addresses and all of those addresses are on file. Is that really inaccurate? And what might that mean for the platform and for me? While definitely I'm not living in any of those addresses, and at some point in time it was correct, it no longer is. Perhaps that means that the platform could the most that the platform could do in these situations is perhaps a prompt saying, do you still want to keep this address? You haven't used this in 5 years. Maybe a prompt like that, some kind of tooling, something that we build out within the platform UI itself again, to again demonstrate good faith and demonstrate reasonable efforts to, like, an attempt to ensure accuracy.
Yeah.
Yeah.
Yeah, maybe I'll actually contextualize this with an example. And we did this as a case study many years ago in our office. Truecaller has Tanya's information. The user's name is Tanya. Tanya has never downloaded the Truecaller app, but the contact book information about Tanya that Truecaller has gleaned from various different users is that Tanya's name is saved as Lazy-ya, for instance, some profanity, something not so flattering. In various, her friends have saved her, called her that in college, and they've saved her saved that name Lazy-ya in their contact book. Tanya goes, applies for a job. She calls the recruiter up. The recruiter sees Truecaller's name ID pop up and it says lazy ya. Immediately notes that, well, either notes that, is that her name, or understands that, well, this is the name she's called by many of her contacts. And Truecaller is popping up that name. It's embarrassing for Tanya. Now, a couple of things. I'll break the question into three bits actually. First, does Truecaller have a positive, proactive obligation to correct Tanya's name from Lazy to Tanya? Even if out of 500 contacts, 499 said Lazy but one said Tanya, do they have a proactive obligation? Two, Tanya goes, she sees this lazy on the recruiter's phone, or is told of this by the recruiter. She goes to Truecaller and says two things. One, hey, why did you not take any proactive measures to correct this? This has done tremendous damage to me. Two, now I'm asking you to correct it. Correct the name from Lazia to Tanya. Do you think Truecaller could push back and say, I never claimed that your name is Tanya or Lazia. I only showed what the majority of your contact book has saved your name as. I never claimed. So, in that sense, the information is actually authentic. If I was claiming your name is Tanya, yes, that's inaccurate, but I never made that claim. Can Truecaller take that defense?
I think in the second question, on when Tanya has herself gone to Truecaller, said, look, this is not my name, please change it. I think there the burden is slightly higher on Truecaller, because that's Tanya is going saying, buddy, this is my name, please correct it. That sort of reactive bit. Yeah, and but I think it would be reasonable for the app then to ask Tanya to actually show that this is really my name. I don't think that would be unreasonable. It also depends on the original framing of the purpose of the app. Is it to show how people's names would be stored on different, in different people's contact book, or is it to actually show their name? If it is the name, then an individual is coming up to you and saying, this is not how my name is pronounced, or this is not my name at all. And maybe upload something along with that. Look, this is my name, this is how I use it. I think there's a higher shade of obligation there. On whether there is a proactive obligation to correct, I think the most reasonable thing that Truecaller could do without Tanya actually saying, here's my name, please correct it, what it might be, is say if 50 people have saved her name as lazy, but or something profane or whatever it might be, and but 20 others have also stored her name as Tanya. At least some kind of a question or some sort of prompt to Tanya herself, because we'd assume in this situation that information is only coming from Tanya, because the right to correction erasure is also available in those instances only. So some kind of a prompt saying, hey, people have actually stored your name as something else. What is the correct? Some sort of, again, I would say good faith or reasonable effort that you demonstrate there, to indicate like what did you do when you saw that there were 50 people with this, but also a sizable sort of number that said something else. So I think that prompt there or some question there, if you've put in, at least that shows effort on your part. Curious to know if you also have thoughts on if there's anything else that they could be doing.
I think it is a fair legal defense to say that Truecaller is not a platform showing people's names. It is a platform which shows the name by which your phone number is saved by a majority of your contacts. Where I think that there would be a breakdown with the compliance of the DPDP for a platform like this is they are relying on Aprajita to get consent from Srinidhi. They may or may not have a contractual relationship with Srinidhi to get consent from Srinidhi to have her number in the Truecaller system. And I think there they'll get caught that whether or not you're showing data accurately about me, did you even have a right to show it in the first place? There are two kind of aspects to this, right? One is what my name is, the other is how my contacts save my name against my number. How my contacts save my name against my number, a data principal can well argue that that is my personal data, it's my phone number, it's my name saved by my friend. the data fiduciary, the platform doing this, can well argue that no, actually, Srinidhi saving Aprajita's name and phone number is Srinidhi's data, not Aprajita's data. I think that's a weak defense. And I think platforms which are relying on this circuitous consent of asking data principals to ask other users to get consent for their data, this step down consent, will be very, very difficult to, it won't withstand, I think, the brute force of the DPDP, which is so kind of granular about how consent is taken, how you want to protect the rights of the user, etc. So I think Tanya can go to Truecaller and say, correct my data, or tell each one of your users that this isn't, we're not populating names, but we're populating phone book entries. Have that blaring on your UI UX, have that distortion on your UI UX. I think those are the two options, but I think it's a fair legal defense for Truecaller to say, well, I never claimed that Tanya was Lazia was your name. I only claimed that your friends stored it as Lazia. I think that's kind of a little bit of trickery. Okay, I'm being mindful of time, Srini. There's a bunch of other questions. I want to come to what information can a data principal, what information can a user go and ask the platform to provide her about herself? And as just as a jump off point, can I go to Zomato tomorrow and tell them, hey, how much have I spent in this year? For me, that number would be embarrassing, but I would like to know.
So, individuals can ask data fiduciaries to share a summary of the data that's being processed and what processing activities they've undertaken, the identities of all data fiduciaries and data processors with whom they've shared data, not just categories. Categories would be broadly service providers or group companies, but this is essentially saying, and those categories we typically see in privacy policies, but the individuals have a right to slightly probe deeper and ask what are the identities of the individual service providers or the individual data fiduciaries with whom you shared my data. Now, interestingly, now your question on can I ask Zomato about my spends? I think how much I've spent, I don't know if that is the remit of this law, whether I can dictate and ask Zomato, tell me exactly how much I've spent. I can definitely ask them, and they are obliged to tell me the fact that they have my order history, or the fact that they have my total spends, or the fact that they have my insights, a summary of what that might mean. But I don't know if this necessarily means that the insight as well, like the total cumulative spends, can I, is that, I mean, it sounds like a reasonable next step that, look, I have all of this data, and the next question will be, well, tell me. But is that really the remit of the data protection law? To my mind, that sounds more like a consumer protection problem. But yeah.
Aligned, actually, and if you notice, these e-commerce platforms never tell you how much you spent. There's an order history, but I can never look up on an e-commerce platform or a food delivery platform how much I spent in a year, because obviously if I see that shocking number, I want to realign my life. um, which is why you have apps like Walnut or Axio now, which is basically going to pick up the spends from your SMS history, etc., and then populate. This is how much you spent on Zomato. This is how much you spent on Amazon. Would you like to change your spending pattern in any way? But I think that asking a platform for my order history is my data, but asking a platform to add up all of the amounts I spent in 2023 is an insight. That insight the platform can choose to give me, but should not be compelled to give me in the DPDP. I've not read anything in the DPDP which says that you should do data analytics on my data and give me the data analytics. You can do data analytics for your purposes, but providing it to me, I think that's a slightly rich interpretation. And I agree with you. Go under consumer protection law for these kind of issues. It's a broader, it's meant for the consumer's interest. And you may be able to get some insights there, but no, I don't think DPDP is a right route to go down.
But just a brief, I think just the fact that I process it for these purposes to generate insights, that I think is within the remit of the DPDP law.
Yeah.
Summary plus what is it that I'm actually using that data for, that much is fair. But asking them to tell me more and more, I don't know if that is, strictly within the data protection laws remit.
Fair, fair. In what form, I'm a user, in what form do I need to make a request from Zomato to give me my XYZ data?
So the law says that the government will prescribe these methods, but what we've seen, I think the most common one that we've all seen is just there's a line in the privacy policy which will say, please reach out to our grievance officer for any queries around data use, and if you have any grievances, reach out to them. And that will perhaps that's most likely to in any case be one of the ways in which individuals can reach out, and organizations must provide that. That's the first port of call, grievance redressal. You must publish the name, contact details of a grievance officer or a data protection officer. But I do think there is room for some tooling, some dashboards also to be built out within the platform itself. um, it where the only place where the law actually requires you to do that is for I mean, I don't know if we can say that that's the only way to do it, but where it requires comparable ease for withdrawal of consent, it should be as easy to withdraw consent as it is to give consent. Which is interesting, right? Because often it is, you can give consent with the click of a button, but it might not be as easy to build out those dashboards or the tooling to enable people to withdraw consent. There's a little more nuance perhaps involved in withdrawal of consent, which just a button might not actually capture, which is why there's a typically like an email or some other communication that you do. But we have seen, at least with larger platforms, there are dashboards within the platform itself where individuals can say access what make a request for data or ask for or for a summary of their data, or even within the app a contact us. And maybe there can be a separate, a box for feedback around data, and you can ask queries. So I do think that some kind of tooling or something in the workflow itself would be desirable. But again, the government may come out with even a risk based on nature of, depending on the nature of the platform, what is the kind of method that is necessary. If it is app based, then it is sort of easier to have something within the app. If it is a different kind of relationship, then it's email communication or any other, the way that you most commonly or routinely engage with the individual. I think that platform should have some means of the individual also reaching out to you. And the privacy notice the notice that we discussed last time around has to tell you, one of the things that it has to tell you is how you can exercise those rights. So that also should be, sufficiently clear within the UI itself on how is it that you can make a request for all of these things.
Okay, I'm mindful of time. We only have 3 minutes left. Quickly, my last questions to you, Srinidhi, are DPDP versus the GDPR. How does the obligations of a data fiduciary differ under these two laws? How do the rights of an individual differ under these two laws? What's the alpha, or what's the delta between the two?
So yeah, this is a question we often get on, if we are GDPR compliant, does that mean we're automatically complying with the PDP? And the answer is no. While a lot of the principles and the core processes that you'll have to build out are similar, but it is not exactly the same. Consent is a prime example of this, because under the GDPR, there are 6 different grounds under which you can process data. And there is a residuary ground of legitimate interest, or there is, a larger, where there's some level of discretion to the data controller. We don't have that under the PDP. So it is slightly more consent centric than what we're used to under the GDPR. So it's not exactly the same. You will have to find or figure how you're, collecting, processing data, what are the legal bases under which you're doing it. The obligations are similar, but not exactly the same. For example, breach is defined differently. In the DPDP, unauthorized processing is also breach, and you must report both to the board and to the affected individuals. Time period is not specified in the law, while a time period is specified in the GDPR. Breach is defined differently. So there are these sort of differences in the way these nuances are different. Broadly, the high level, at least the principles are the same: purpose, consent, transparency. While our law doesn't say data protection by design or privacy by design, unlike the GDPR, it does say organizational and technical measures to implement the act, which mean the same thing. So while the principles high level at least might be the same, it's not completely reimagining it, but what it eventually looks like, say in the contract or in the UI, might be different. What you can do under the GDPR, you might not be able to do under the DPDP, and vice versa as well. So that's just something to be mindful of, I think, for most platforms. And the rights are also different. There are more rights under the GDPR that individuals have. There's the right to portability. So individuals could also seek porting of their data from one platform to another in interoperable formats. Then individuals could object to processing in certain circumstances. They have the right to say no to automated decision making in certain circumstances. But the DPDP is different. So slightly sort of narrower set of rights for individuals there. So yeah, that's broadly it. I think the takeaway just being, while a lot of the processes that you build out are similar, it is, one should not automatically assume compliance just because you've reached a certain stage in your GDPR compliance journey.
Got it. I think those are my last questions. We're at time. Thank you, everyone. Thank you for joining us. Thanks, Srinidhi. This is another wonderful webinar. I think, Srinidhi, do you want to announce our next webinar?
Yeah. Thank you so much, everyone, for oral interplay. We'll discuss in particular, I think, a couple of these different platforms. Fintech, of course, of Rajasthan. I've been bringing up many of these examples, but we'll also delve into what this might mean for edtech platforms. I think so far we haven't talked about what do you have to do if you're processing children's data. So that's something we'll pick up. What it means for AI developers, AI-based platforms, what it means for health tech platforms. So those are 4 sectors that we'll look to touch upon. Just any unique considerations that one should think of beyond the ordinary do's and don'ts of the PDP. So yeah, looking forward to seeing everyone on at the next session. And thank you so much for joining us today. Thanks so much, Aprajita. Bye bye.